Hi, I'm Connor Ross.
I'm Abdullah Wal.
I'm Fraser Jones.
And my name is Mukhtar Malik, and today we're going to talk about contract law. That's it. What is needed to form a contract? A contract can be defined as a legally binding agreement. Contracts are made where there is an agreement between two or more parties. This means that an agreement is valid offer, which is then followed by a valid acceptance. A contract is complete when both sides carry out their part of the agreement. If any of the parties fail to do so, then the contract will be in breach. A contract can be defined in a few ways. An example would be an oral contract, where an agreement is made by speaking to another party and then both verbally agreeing to the contract. This can be between two people. For example, if I wanted to sell my pen to one of my classmates, I will ask my classmates if they are interested in buying my pen for 50p, and if they say yes and give me money and shake my hand, I have successfully made an oral contract. Another type of contract is a written contract. These are seen as more serious contracts and generally done by businesses. An example would be where a person is offered to work for a company for a 1-year contract. The contract will be paper-based, containing the terms and conditions that the employee will have to follow if he wants the job. What is needed to form a contract? A contract can be defined as a legally binding agreement. Contracts are made where there is an agreement between two or more parties. This means that an agreement is a valid offer, which is then followed by valid acceptance. A contract is complete when both sides carry out their part of the agreement. If any of the parties fail to do so, then the agreement would be in breach. A contract can be created in a few ways. An example would be a oral contract, where the agreement is made by speaking to another party, then both verbally agreeing to the contract. This can be between two people. For example, if I wanted to sell my pen to one of my mates, I would ask him, would you like to buy this pen for £1?
Yeah, I do.
And if they give me the money and shake my hand, I have successfully created a verbal contract. Another type of contract is a written contract. These are seen as more serious contracts and generally done by businesses. An example would be where a person is offered to work for a company for a 1-year contract. The contract will be paper-based, containing the terms and conditions which the employee will have to follow if he wants the job.
What is needed to form what is needed to form an agreement? The offer. The beginning point of a contract is the offer. The person who makes the offer is known as the offerer, and the person who is given the offer is known as the offeree. An example of case law offer is Carlisle v. Carbolic Smoke Ball Co. Limited, 1893. The defendant was a Carbolic Smoke Ball company who created an advertisement offering £100 to anyone who got influenza after having used one of the smoke balls the way it is meant to be used. The company deposited £1,000 into the bank. This showed a commitment from the company. The defendant argued that the advertisement was a mere invitation to treat rather than offer, but the Court of Appeal held that Miss Carlisle was entitled to the reward. Miss Carlisle accepted the offer by conduct by doing what the company said to do with the product. Yeah, done.
The second stage of a contract. There is no contract until the offer is accepted. The acceptance has to match the offer. The name itself explains it all. An offer can be accepted in the form such as orally. A simple "yes, I agree" will complete the contract. If one party, without expressing anything in words, starts to behave as if he has accepted the offer, the court will assume he or she has accepted, so the offers can be accepted by conduct. What is an invitation to treat? There is a big difference between an offer and an invitation to treat. An offer is basically a statement made by one party to another, for example, saying to the other, "Do you want to buy my pen for 50 pence?" to which the offeree would accept or decline. Whereas an invitation to treat, the process is quite different, a bit more complex. An invitation to treat is not an offer. If you walk into a store and see products on the shelf, they are invitations to treat. This is an invitation to the buyer to make an offer to buy. This is done by the customer taking the product to the till where the contract is formed when the sale is agreed. A case example of this is the Pharmaceutical Society of GB vs Boots Cash Chemist Ltd 1953. In this case, Boots Cash Chemist Boots Cash Chemist created a new way to let customers buy medicine by letting customers pick items up from the shelves and take them instead of having an assistant or with a till get the medicine. A customer requested the court held that the medicine on the shelves constituted an invitation to treat, not an offer.
The whole purpose of intention to create legal relations in contract law is to sift out the cases that are not appropriate to be taken to court. Not every single agreement leads to a binding contract which can be enforced through the courts. For example, you have an agreement to meet your friend outside college. You do not have a moral duty to honour that agreement, but there is a legal duty to do so. In order for a contract to be valid, the parties must intend for it to be legally binding in order to determine whether an agreement was meant to be legally binding. In the courts treat domestic and social agreements in a different way compared to business agreements. The courts make rebuttable presumptions regarding intention. The rebuttable presumption in social and domestic agreements means that the courts will presume there was no legal intention unless the parties prove there was. In business and commercial agreements, the court presumes that there was legal intention unless the parties can prove there wasn't.
Social and domestic agreements. These types of agreements are considered as not to have the intention to create legal relations that are enforceable by the courts. This is where the families agree to do something on a daily basis, such as who picks up the kids and who will do the shopping. It is very unlikely that the person in these type of situations that the court would intervene and use legal power to enforce these agreements. If they did, there would be a lot of family cases at the court.
An example of case law involving social and domestic agreements is in the case of Balfour v. Balfour 1919. In this case, there was a couple where the husband worked overseas and said to his wife that he will send maintenance payments to his wife. At this point, the couple were happily married, but later during their relationship it ended badly and the husband stopped making payments. So the wife tried to enforce the agreement. The court held that the agreement was a domestic agreement and the court refused to intervene.
And the court will say there is an intention to be legally bound in social and domestic agreement. This can be seen in the case of Merritt v. Merritt 1970. In this case, the husband left his wife to be with another woman. There were money to be left to be paid on the house, which was jointly owned by the couple. The husband created a written contract by signing an agreement to pay his wife money every month so she could pay for the mortgage until it was fully paid off. After it was fully paid for, the wife brought an action for a declaration that the house belonged to her. The court held that the agreement was legally binding.
Commercial and business agreements. For business agreements, courts start with the presumption that the agreements that are made are legally binding. An example of a case involving commercial and business agreement was Rose v. Frank Crompton Bros 1924. In this case, the claimants and the defendants entered into an agreement for the supply of tissue paper. The agreement said the claimants were to be defendants' sole agents in the US until March 1990. The contract contained an honourable pledge clause which stated that the agreement was not legally binding. The court held that the honourable pledge clause rebutted the presumption that his parties wanted to be legally bound. As a result, the court decided the agreement was not legally binding and so was not enforceable by the courts.
How a contract is formed.
Thank you for watching our video.